they asked me to withhold it.
Why?
It seems they have not. This is the fact. It seems they have not applied their mind. Despite my communication, they arrived late, and I told them these are the risks. Now, at the last moment, it appears there has been some discussion between the corporation and the department. Now they want me to withhold it. This is the
No,
true
now
fact.
that when we will
Sir,
clarify
the decision was already taken as early as 11/1/2022 itself.
No, if that is the case, we'll ask that original record to see what is that.
Yes.
Proceedings has been taken on that.
11/1/22, they have enclosed. That decision has already been taken. Now they cannot undo that decision.
Yes, when do you want?
A week's time is sufficient. Please.
Yes, at the request of government advocate to comply. Order dated 19/8/20.
19/8.
Is this matter on 24th?
Please.
Yes.
But can it be on 23rd, Mala?
23rd.
Or 22, Mala?
23rd. 22, so many matters are there.
23rd.
23rd, yes.
Grateful, ma'am.
Password.
Please.
Serial number 46 disposed of, 47 adjourned, 48 Vikram Balaji for petitioner, Vaishali Agde. Serial number 48.
Yes.
Component numbers 2 and 3, my lord. My lords, my objections are ready. I had to file objections to their petition. Objections are ready. I'll file it in the registry, my lords.
What is that objection?
My lords, this is a matter where the petitioner is seeking higher AGP. And in our objections, we have stated that he did not fulfill the necessary qualification. That is, PhD is mandatory, my lords, as per UGC regulations.
Have you served the copy?
I'll serve them and I'll file it in the registry, my lord.
Yes, Mr.
Yeah, I got it.
Give
in
the copy.
Next week, your lordship.
Yes. At the request of counsel for the respondent.
Without a PhD, 5 years experience,
Yes.
that is sufficient for,
Yes, 18.
Great.
Serial number 49 Prakash MH for petitioner, and Jakarta. 49.
Against warehouse corporation.
Same.
Same in the sense, making me responsible for delaying lifting the food grains. The inquiry was initiated. In fact, it results in a serious, disciplinary action of termination.
Yes.
Appeal is to be filed before the executive committee, wherein chairman is yet to be appointed.
Oh, that is
Lord,
what last.
The facts are this, my lord. The minimum support price scheme nalli bhatta dastan ಮಾಡ್ತಾರೆ. I was in charge of the particular warehouse. If the lifting of the food grains goes beyond certain time, then the weight will come down. Despite the fact that I have intimated regarding the reduce in moisturizer of the grains, the lifting was not taken because it is the paramount authority of the government to lift at a particular.
Yes.
So ultimately, when all the food grains were lifted, there is shortfall of the weight. So by making me held responsible because I have not.
No, there will be a scientific assessment.
Yes.
What will be that shortfall? Not like shortfall, what you have said.
That
Is it some percentage?
That is, by making me responsible, but alleging that.
You can't take that advantage and make it a shortfall is more than what required under that advantage and make it a shortfall is more than what required under that.
It is only on scientific,
No, how much shortfall, what is that extent? Yes.
In fact, what
Mandamus.
Yes.
Appeal, yes.
In fact,
Now
last
appellate
case-
authority is not there. What is that mean? Yes, Mr. You are not appointing anybody. Who is in charge now?
executive committee consisting of
No, if that MD is not there, who is that in charge? What is?
chairman, political appointment.
No, that appeal is provided for a chairperson
Yes,
or a board.
Before the executive. Executive.
Yes.
And why?
What is that EC? It's a committee.
Committee managed.
You give that. Yes. Yes. Hmm. Yes, executive committee.
Yes.
Yes. Where is that executive committee definition? Who are that executive? No, let us see. Executive committee is consisting of how many members?
Managing director.
In the absence of chairman, it cannot be held. Appellate authority appoint into group A post shall be made by the executive committee to group C and D post managing director based upon the recommendation for recruitment of constituent. Recruitment committee shall consisting of chairman of the board director, so and so. Notice recording the leave, so and so. Now, what is that? If it is not there, then what they have to be executive committee? Impossible. Pay of alliance, invalidate applications, library. You are not challenging that penalty order.
Penalty.
You are challenged also.
In the appeal, because
No,
of,
no, no, no. Now there is no appellate authority. Then you can directly file this
That's why,
court.
in fact, the last occasion I made a mention. So that
You had-
my lord
if it is
permit
not
me,
there, then they can challenge
I
it
can,
before this.
I have to, refine the.
If appellate authority is not there, then he can challenge it before this court.
Please, sir. In fact, the last occasion I made the submission subject to.
Yes. Suppose if they are not appointed for another 2 years, he cannot be kept quiet then.
I may be permitted to amend the writ petition suitably.
You file an application.
Please.
Yes. No. See, let them file an application. By the time if you are appointed or you are giving an assurance that another 2 weeks or 1 month, then we can dispose of. IA may be disposed. Otherwise, he can't wait. Yes, you see, is there any in charge can be done by the committee? Yes. Because so many other duties has given a committee. Can it be without that committee can be done it or not?
Can't say, simply sit quiet. So
Yes,
just
there are
because
so-
of the fact that the chairman is not appointed.
Yes. Yes. Leave this matter up to 2 weeks.
Serial number 50 disposed of. Serial number 51, Ramesh K.R. for petitioner, government advocate. Kindly pass it.
Pass on.
52, Vaishali Agade for petitioner, Shubha S. H.V. Devaraju.
At the request of counsel for the petitioner, leaves this matter after 10 days.
Serial number 53,
Here
Mutagunti
petitioner, my lord. Here in this case,
Somayaji.
petitioner seeking the regularization of this, the ML Kesari case and the Marci Das case and the Sitalakshmi case. He is submitted the representation before the response number 3. But under the annexure fee, endorsement issued and reject the.
Why it is rejected?
Under the impression of the panel advocate opinion of the response number 3 under the Umadevi case.
Yes.
Under condition number 1 and 4 and rejected the petitioner's request under the direction of the.
Annexure P page.
Annexure P.
PP.
Is it 158 in my definition? 158.
158.
He is making a grievance to implement the government. He is making a grievance to implement the government order. The government order at page number 39. Kindly see the my lord. Page number 39.
Yes.
ಅನುದಾನ ರಹಿತ ಖಾಸಗಿ ಕಾನೂನು ಕಾಲೇಜುಗಳ ಸಂಘದ ಮನವಿಗಳನ್ನು ಪರಿಶೀಲಿಸುತ್ತಾ ಸರ್ಕಾರವು ಪ್ರೊಫೆಸರ್ ಮಾಲಿ ಮುದ್ದಣ್ಣ ಸಮಿತಿ ವರದಿಯನ್ನಾಧರಿಸಿ 24 ಖಾಸಗಿ ಕಾನೂನು ಕಾಲೇಜುಗಳನ್ನು ವೇತನಾಧನಕ್ಕೆ ಒಳಪಡಿಸಿ ಹೊರಡಿಸಲಾದ ಸರ್ಕಾರಿ ಆದೇಶ 4/10/99 ಪುನಶ್ಚೇತನಗೊಳಿಸುತ್ತಾ ಅವುಗಳ ಪೈಕಿ ಪ್ರಸ್ತುತ ಸುಸ್ಥಿತಿಯಲ್ಲಿರುವ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳಿಗೆ 5 ವರ್ಷದ LLB ಕೋರ್ಸ್, 3 ವರ್ಷದ LLB ಕೋರ್ಸ್ ಅಥವಾ 2 ವರ್ಷದ LLB ಕೋರ್ಸ್ ನಡೆಸಲು ಸಂಯೋಜನೆ ಮಾಡಿದ್ದ ಈ ಕೆಳಗೆ ಕಾಣಿಸಿದ 19 ಖಾಸಗಿ ಕಾನೂನು ಹರ್ಷಿಸುತ್ತದೆ. ಇದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 5 ನಂದು ವಿವಿಪುರಂ ಲಾ ಕಾಲೇಜ್ ಬೆಂಗಳೂರು, ಒಟ್ಟು 19 ಕಾಲೇಜು. ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 41 ಕ್ಲಾಸ್ 12 ಮೈನರ್, ಕ್ಲಾಸ್ 12 ಸಹಾಯಧನವು ಕ್ಲಾಸ್ 12 ಸಹಾಯಧನವು ದಿನಾಂಕ 1/1/13ರಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಅನ್ವಯವಾಗುವುದು. ಲೆಕ್ಕಪತ್ರ ವ್ಯವಸ್ಥೆಗಳನ್ನು ಅಲ್ಲದೆ ಮಧ್ಯದ ಅವಧಿಯನ್ನು ಇಲಾಖೆ ಕಾಲೇಜುಗಳಿಂದ ಹರಣ ವಿವರಗಳನ್ನು ಪಡೆದು ಪರಿಶೀಲಿಸಿ ಉಪಯೋಗಿಸಿಕೊಳ್ಳಬೇಕು. ಆಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 44 ಅನೆಕ್ಷರ್ H ಸರ್ಕಾರಿ ಆದೇಶ ಸೋನ್ ಇದರ ಪ್ರಕಾರ ಪ್ರತಿ ಡಿಸ್ಟ್ರಿಕ್ಟಿಗೂ ಈ ರಿಪೋರ್ಟ್ ಒಂದು ಆಯಾ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಇಂದ ಬಂತು. ಅದು ಬರೋದಕ್ಕೆ ರಿಪೋರ್ಟ್ ನಮ್ಮ ವಿವಿಪುರಂ ಲಾ ಕಾಲೇಜಿಗೆ ಬರೋಕ್ಕೆ ಲೇಟ್ ಆಯಿತು. ಲೇಟ್ ಆಗಿ ಈಗ ಆರ್ಡರ್ ಏನಾಯಿತು ಅಂದರೆ ದೆನ್ ದಿಸ್ ಆರ್ಡರ್ ಮೇಡ್ ಇಟ್ ದಿಸ್ ಆರ್ಡರ್ ಕಾಂಟ್ರರಿ ಟು ದಿ ಅರ್ಲಿಯರ್ ಗೌರ್ಮೆಂಟ್ ಆರ್ಡರ್. ಅರ್ಲಿಯರ್ ಗೌರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಸೆಟ್ ದಟ್ 13 ಇಂದಾನೆ ಬರುತ್ತೆ ಅಂತೇಳಿ. 13ನಲ್ಲಿ ಐ ವಾಸ್ ಇನ್ ಸರ್ವಿಸ್.
ಎಲ್ಲಿದೆ 13 ಇಂದ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ?
ಅಲ್ಲಿ ಫಸ್ಟ್ ಆರ್ಡರ್ ನಾವು ಓದಿದ್ನಲ್ಲ ಅದು ತೋರಿಸ್ತೇನೆ. ಪೇಜ್ ನಂಬರ್ 39.
Yes.
39ನಲ್ಲಿ ವೇತನ ಸರ್ಕಾರ ಹರ್ಷಿಸುತ್ತದೆ ಅಂದಮೇಲೆ ಕ್ಲಾಸ್ ನಂಬರ್ 12 ಅದಲ್ಲ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ 41 ಸಹಾಯಧನವು ದಿನಾಂಕ 1/1/13ರಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಅನ್ವಯವಾಗುವುದು.
1/1/13ರಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಅನ್ವಯವಾಗುವುದು.
1/1/13ರಲ್ಲಿ ನಾನು ಪ್ರಿನ್ಸಿಪಾಲ್ ಆಗಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೆ ವಿವಿಪುರಂ ಲಾ ಕಾಲೇಜ್ನಲ್ಲಿ. ಅದೇನಾಯ್ತು ಅಂದ್ರೆ ಇದನ್ನ ವೆರಿಫೈ ಮಾಡಿ ಪ್ರತಿಯೊಂದು ಕಾಲೇಜಿಗೂ ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ಆರ್ಡರ್ ಮಾಡಕ್ಕೆ ಲೇಟ್ ಆಯ್ತು. ವೆನ್ ದ ಫಸ್ಟ್ ಆರ್ಡರ್ ಸೇಸ್ ಕ್ಲಿಯರ್ಲಿ ಆನ್ 1/1/13, ದಿ ಸೆಕೆಂಡ್ ಆರ್ಡರ್ ಶುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ಬೀನ್ ಫಿಕ್ಸ್ಡ್ ಲೇಟರ್ ಡೇಟ್.
ಎಲ್ಲಿ 1/1/13 ಫಸ್ಟ್ ಆರ್ಡರ್?
ಅದೇ ನಾನು ಓದ್ನಲ್ಲ ಪೇಜ್ ನಂಬರ್ 41. ಸಹಾಯಧನವು ದಿನಾಂಕ 1/1/13ರಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಅನ್ವಯವಾಗುವುದು.
ಸೆಕೆಂಡ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ?
ಸೆಕೆಂಡ್ ಆರ್ಡರ್ ಪೇಜ್ ನಂಬರ್ 51 26/8/15 ನಮ್ಮ ಕಾಲೇಜಿಗೆ ಆಗಿದ್ದು. ಪ್ರತಿ ಕಾಲೇಜಿಗೂ ಒಂದೊಂದು ಆರ್ಡರ್ ಆಗ್ತಾ ಹೋಯ್ತು. ಯಾಕಂದ್ರೆ ಬೇಸ್ಡ್ ಆನ್ ದಟ್ ಗೌರ್ಮೆಂಟ್ ಆರ್ಡರ್. ಇದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 54 ಕ್ಲಾಸ್ 6 ಸಿಬ್ಬಂದಿಗಳ ವೇತನವನ್ನು ಈ ಆದೇಶ ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ ಜಾರಿಗೆ ಬರುತ್ತದೆ. ಚಾಲೆಂಜಿಂಗ್ ದಿಸ್ ಕ್ಲಾಸ್ ಐ ಫೈಲ್ಡ್ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ಬಿಫೋರ್ ದಿಸ್ ಆಂಬಲ್ ಕೋರ್ಟ್ in a writ petition number 58817 of 16 annexure L. ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಏನಾಯ್ತು ಅಂದ್ರೆ ಪೇಜ್ ನಂಬರ್ 72 this honorable court passed an order. This writ 72.
Yes.
This writ petition is allowed gratuity and other benefits ಅಂತ ಇದೆ.
ಏನಾಯ್ತು ಈಗ ಆಮೇಲೆ?
ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಅದ್ರ ಇದೇ ಆರ್ಡರ್ ತಪ್ಪು, ನಾನು ಅಪೀಲ್ ಹೋಯ್ದೆ, ಅಪೀಲ್ ನಲ್ಲಿ ಇನ್ನೂ ಅದೇ ಆರ್ಡರ್ ಇರ್ಲಿ ಬಿಡಿ ಅಂದ್ರು. ಈ ಪ್ರೆಸೆಂಟ್ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್ ಹ್ಯಾಸ್ ಬೀನ್ ಪಾಸ್ಡ್, ಟೈಪ್ಡ್ ಕಾಪಿ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 82 ನಲ್ಲಿ ಹಾಕಿದ್ದೇನೆ. 25/6/24 ಈ ಪ್ರೆಸೆಂಟ್ ಆರ್ಡರ್. ಈ ಪ್ರೆಸೆಂಟ್ ಆರ್ಡರ್ ನಲ್ಲಿ ತುಂಬಾ ಎಲ್ಲ ಪ್ರಿಯಾಂಬಲ್ ತುಂಬಾ ಹೇಳಿ ಲಾಸ್ಟಿಗೆ ತಾವು ಪೇಜ್ ನಂಬರ್ 89 ಬರ್ಬೋದು ಸರ್. 89 condition stipulates so and so. Purview of grant in aid, you have attained the age of retirement and retired on 28/2/14. Thus, your request for extending your grant in aid from 1/1/2013 or from 26/8/15 is hereby rejected. ನಾ 15 ಇಂದ ಮಾಡಿಂದ ನಾ ಕೇಳಕ್ ಬರೋದೇ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ರಿಟೈರ್ ಆಗ್ಬಿಟ್ಟಿದೆ. ನನ್ನ ಕ್ಲೈಮ್ ಈಸ್ 1/1/13 ಇಂದ. ನಾ 14 ನಲ್ಲಿ ರಿಟೈರ್ ಆಗಿದ್ರು ಸರ್ವಿಸ್ ನಲ್ಲಿದ್ದೆ. ಐ ಆಮ್ ಎಂಟೈಟಲ್ ಫಾರ್ ಆಸ್ ಪರ್ ದಟ್ ಆರ್ಡರ್. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಇನ್ನೊಂದು ಗ್ರೌಂಡ್ ಹೇಳ್ತಾರೆ ಅವರು, Second, the question of payment of pension arise only in case where
Which
the-
paragraph?
Huh?
89.
Otherline, page number 18 NL. Second paragraph. Admitted into the purview of grant in aid prior to 31/3/2006, as per the details stated above, though you have appointed prior to 31/3/2006, but your post was not at all admitted grant in aid prior to 31/3/2006, as such the question of payment of pension has upheld the contention of 55 marks in its order dated 5/5/2000. The Honorable Punjab Haryana High Court also, in its order rendered the case of so and so, has upheld the contention of 55% marks. Therefore, exclusion of your name from the grant in aid as per order dated is perfectly legal. Insofar as this third contention, acquiring 55% marks is concerned, UGC has issued a notification that your last may kindly see me. Page number 22. UGC notification dated 22/11 notification 22. UGC notification dated 22/11/2001.
Yes.
UGC regulation prakara, any colleges teacher has to obtain 55% is a minimum with in the MA or MSc. In continuation of UGC notification dated 24/12/98 and regulation so and so regarding revision of pay scale and minimum qualification of teachers, I would like to inform you that the minimum requirement of 55% marks at master's level shall not be insisted upon for principals, professor, readers, registrar, deputy registrar, librarian, deputy librarian, directors of physical education, deputy director of physical education for the existing incumbents who are already in the university system. ಈಗ ನಾನು ಸೇರಿದ್ದು ಕಾಲೇಜಿಗೆ 84 ಅಲ್ಲಿ, ಆಮೇಲೆ ರೀಡರ್ ಆದೆ, ಪ್ರೊಫೆಸರ್ ಆದೆ, ಪ್ರಿನ್ಸಿಪಾಲ್ ಆದೆ. 98ನಲ್ಲಿ ರೂಲ್ಸ್ ಬಂದಾಗ ಆಲ್ರೆಡಿ ನಾನು ಪ್ರೊಫೆಸರ್ ಆಗಿದ್ದೆ, ವರ್ಕ್ ಮಾಡ್ತಾ ಇದ್ದೆ. ಆದ್ರಿಂದ ಆ 55% ಅನ್ನೋದನ್ನ ಅದು ಅಪ್ಲೈ ಆಗಲ್ಲ.
Yes, Mr.
ಈಗ 26/8/2015 ವಿವಿಪುರ ಲಾ ಕಾಲೇಜ್ಗೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕಾದ್ರೆ the earlier government order has been diluted. They can't dilute it because first order clearly says it should come from 1/1/2013. That's all my submission. Each college different date ನಲ್ಲಿ ಆಗಿದೆ, ಒಂದೇ ದಿವಸ ಆಗಲಿಲ್ಲ. ಆಟೋಮೆಟಿಕ್ ಇವತ್ತೇ ಕೊಟ್ಬಿಟ್ಟಿದೆ ಎಲ್ಲರಿಗೂ ಅಂತ ಹೇಳಲಿಲ್ಲ ಅಲ್ಲಿ. ಅದಕ್ಕೆ ಕಮಿಟಿ ಫಾರ್ಮ್ ಮಾಡಿದ್ರು, ಆ ಕಮಿಟಿ ಈಚ್ ಕಾಲೇಜನ್ನು ವೆರಿಫೈ ಮಾಡ್ತು, ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಪ್ರಪೋಸಲ್ ಕೊಟ್ಟರು. ಇದೆಲ್ಲ ಆಗಿದ್ರಲ್ಲಿ ಸ್ವಲ್ಪ ಇಟ್ ಕನ್ಸ್ಯೂಮ್ ಸಮ್ ಟೈಮ್ from 13 to 15. This endorsement is absolutely wrong. First, they have to admit me to salary grant from 1/1/13.
Yes, Mr.
Lord, may I make one submission, my lord? The petitioner is seeking an pensionary benefit, my lord. The endorsement is issued. To that to.
No, there are 3 points.
Oblige, my lord.
Pensionary benefit is concerned.
I'm not.
Before his appointment has to be confirmed, he is entitled or not issue pending before the division bench.
Oblige.
Therefore, he said that he is not on that point.
Oblige, my lord.
Now, one point is that he wants to regularize his service from 1/3/2013, not 2006.
1/1/2013.
1/1/2013 is the date he is asking. Second is that as and when he has appointed, there is no qualification that one should have been acquired 55.
Oblige.
That as exemption has been given person who is already,
Lord.
that is not considered by your.
Lord, for that to issue, my lord, I have to replace the document saying that to counter his, whether he is appointed earlier to that, the.
No,
but
yes.
that he is
I've
mentioned.
given-
Has appointed in
84.
84.
84 as
He
a
has
lecturer.
been promoted to the to professor to reader. Now, then you see that UGC letter.
Lord, may I request one thing, Lord? Lord,
You
I have
apply
seen.
all these things and consider that. See, now he is saying that this, he has also placed that letter. Will say that considering all these things, whether he is eligible or not. One thing, he has not seek from 2006. To that extent, your endorsement without application of mine. In respect of pension, yes, he said that till that it is subject to the result. In only things left is that his qualification. He has produced that letter. You verify and pass an order.
Obliged.
All 3 points you have to be reconsidered and passed.
Lot 2 points, 3 points. One is that it is a
Subject to the
pension.
result of the.
And another 2 point is that whether he is having a qualification of that time or one more that the date of appointment that.
Yes, now you said that you have no qualification.
How?
You are applied that as on the date of consideration. That is not that, as on the date of that appointment, he should have been seen.
Lord, one more thing that has to be approved by the authority. That is one aspect. That will be, he will take.
No, see, when you are
She was,
regularizing, admitting that granting aid, first you see that whether now the case is now only you think is that you have retired, therefore I am not doing. That is not his case, because 2013 itself it has to be done it. On that day, if it is considering he is eligible for all criteria, then you can.
Obliged.
Yes. Because all other teachers who has appointed has been admitted to granting aid. Only reason he has superannuated by the time, therefore you have not done it. In this petition, petitioner questioning that order dated 26/8/2015. Erada ಒಂದೇ challenge M ಏನದು?
M and N. M is also endorsement dated 25/6/24, my lord.
ಈಗ present endorsement 25/6/24 annexure M.
Annexure
M.
M.
ಅದರದ್ದು
K ಏನದು?
annexure M page 74 ಅದ್ರ ಟೈಪ್ಡ್ ಕಾಪಿನೂ ಹಾಕಿದೆ ಅಷ್ಟೇ, ಅದು ಕ್ಲಿಯರ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಕೆ ಅಂತ ಕೇಳಿದಿರಲ್ಲ ಪ್ರಯರ್ ಅಲ್ಲಿ.
ಕೆ
ವಾಟ್ ಇಸ್ ದಟ್ ಕೆ?
ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡೇನಂದ್ರೆ ಪೇಜ್ ನಂಬರ್ 54 ನೋಡಿ ಸ್ವಾಮಿ.
ಕೆ ಎಲ್ಲಿದೆ?
ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡೇನಂದ್ರೆ ಪೇಜ್ ನಂಬರ್ 54 ನೋಡಿ ಸ್ವಾಮಿ.
ಕೆ ಎಲ್ಲಿದೆ?
annexure K ಪೇಜ್ ನಂಬರ್ 54. ಈ ಆರ್ಡರ್ 26/8/2015 ಕ್ಲಾಸ್ 6 ನಲ್ಲಿ ಸಿಬ್ಬಂದಿಗಳ ವೇತನವು ಈ ಆದೇಶ ಹೊರಡಿಸಿದ ದಿನಾಂಕದಿಂದ ಜಾರಿಗೆ ಬರುತ್ತದೆ ಅಂದ್ರೆ 2015 ಇಂದ. ಇಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಕಮ್ ಫ್ರಮ್ 13.
No, when you have filed an earlier writ petition, why you have not challenged that?
ಅದನ್ನೇ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೆ ರಿಟ್ ನಲ್ಲಿ. ಬಟ್ ಸಮ್ ದಿಸ್ ಆಂಬಲ್ ಕೋರ್ಟ್.
May I request, my lord, this may not be granted because, my lord, this is order dated and he has subsequently filed two writ petition. This was not his challenge. He has given.
No,
us
he has
a
challenged
earlier
that.
occasion.
Challenge
15. ಇದು 15 order.
ಯಾವುದು?
ಇದು annexure K.
Annexure K?
2015 order annexure K.
ಅದೇ ಆರ್ಡರ್ನ ಅರ್ಲಿಯರ್ ರಿಟ್ ನಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೆ ನಾನು. ಪೇಜ್ ನಂಬರ್ 66 ನಲ್ಲಿ ತಾವು ನೋಡಿ.
2015 ಇಂದ ಚಾಲೆಂಜ್
ಮಾಡಿದ್ದೇನೆ.
But that this is not set
aside that. We'll only consider in terms of that earlier order annexure M. Yes.
ಅದೇನಾಯ್ತು ಅಂತ ಜಡ್ಜ್ಮೆಂಟ್ ರಿಸರ್ವ್ ಅಂತ ಆಯ್ತು, ಆಮೇಲೆ ಬಂತು. ಅದು ನಾನು
ನೀವು ಕ್ಲಾರಿಫಿಕೇಶನ್
ಅವ್ರು ರಿವ್ಯೂ ಹಾಕೋಬೋದಿತ್ತು. ಅವು ಈಗ ಹಂಗೆ
admitted in the granting act 2013 itself.
13.
Yes. Admitted in the granting act 2013 itself.
13.
Yes.
As per annexure F.
ಲಾರ್ಡ್ ಇಲ್ಲೇ 65 ಅಲ್ಲೇ ಹೇಳ್ತಾರೆ ಸರ್. ಮೈ ರೀಡ್ ಮೈ ಲಾರ್ಡ್.
ಅದು ಅಪ್ರೂವ್ಡ್ ಕಾಲೇಜ್ ಮೊದಲಿಂದನ.
The case of the petitioner that petitioner having qualification of BCom LLB and MPhil law. She was appointed as a lecturer in Vivekananda College of Law, Bangalore on 25/8/1984. ಅಲ್ಲೇ ನೀವು ಪ್ರಮೋಷನ್ ಆಗ್ತೀರಾ?
ಹೌದು. ನಾನು ಫಸ್ಟ್ ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್ 1 ಆಫ್ ಲಿಸ್ಟ್ ಆಫ್ ಡೇಸ್ ಸಿನಾಪ್ಸಿಸ್ ಕೈಂಡ್ಲಿ ತಾವು ನೋಡಿ.
ಆಮೇಲೆ ವಿವಿಪುರಮ್ಗೆ ಬರ್ತೀರಾ?
ಆಮೇಲೆ ವಿವಿಪುರಮ್ಗೆ ಬಂದೆ.
ಎಲ್ಲಿ ವಿವಿಪುರಮ್ಗೆ ಯಾವಾಗ ಅಪಾಯಿಂಟ್ ಆಗ್ತೀರಾ?
ಮೈ ಲಾರ್ಡ್, ಫುಲ್ ಟೈಮ್ ಪ್ರಿನ್ಸಿಪಾಲ್ ವಿವೇಕಾನಂದ ಕಾಲೇಜ್ನಲ್ಲಿ 2793 ಇದ್ರು. ಆಮೇಲೆ 13/8/98 ಪಿಟಿಷನರ್ ರೆಂಡರ್ ರೆಸಿಗ್ನೇಷನ್ ಹ್ಯಾವಿಂಗ್ ಸೆಲೆಕ್ಟೆಡ್ ಆಸ್ ರೀಡರ್ ಇನ್ ವಿವಿಪುರಂ ಲಾ ಕಾಲೇಜ್ ಅಂಡ್ ರಿಪೋರ್ಟೆಡ್ ಫಾರ್ ಡ್ಯೂಟಿ ನೆಕ್ಸ್ಟ್ ಡೇ.
Yes.
14/8 petitioner appointed as reader.
Yes.
24/1 petitioner appointed as principal.
Acquired qualification ಹಾಕೊಂಡ್ರಲ್ಲ MPhil. or
List
she
of
was
dates and synopsis dated.
thereby limited, joined
First Vivekananda.
25/8/1984. Thereafter, in the year 1988, she resigned. He has appointed as principal on 21/1/2000.
2000.
On Annexure G order dated
Order page number 32, my lord. Dated 28/11/2012.
on 28/11/2012, government has issued an order
Admitting various law colleges for granting aid.
admitting that various law colleges for granting aid with effect from 1/1/2013.
Otherly class 12.
For that purpose, committee is constituted to examine
Eligibility of each college.
eligibility of each colleges and to recommend for granting aid. Pursuant to that recommendation of the committee, petitioner, pursuant to the recommendation of the Vivipuram Law College was been admitted to. The employees of the Vivipuram Law College has been admitted to granting aid from 26th August 2015.
Those who are in service.
At the time, petitioner the impugn order annexure M has been passed containing that as on the date of admitting the grant aid by order dated 26th August 2015, petitioner was not in that service. He has attained the age of superannuation. In respect of this aspect is concerned, this court in earlier round of litigation in WP number 58817 of 2016 has considered the notification issued by the government dated 28 November 2012,
12.
wherein it is specifically directed that
In class 12.
colleges, without considering this aspect of the matter, the petitioner request has been rejected on the ground that he has attained superannuation before passing the order dated 26th August 2015. This reasoning given by the respondent in impugn endorsement is contrary to the directions issued by this court in WP number 58817 of 2016. In respect of petitioner has requested to grant pension in respect of granting of pension during the period of non-grant
period.
Prior to granting aid. Annexure E, page number 22.
Of UGC letter. University Grant Commission, page number 22.
Communication dated 27 November 2021, where it is communicated to the Vice Chancellor of University.
Of all
The
universities.
same is extracted below. As an extract. Without considering this aspect of the matter, the reason has been given in that impugn endorsement that petitioner was not qualified on this. Therefore, the endorsement has required to be passed. The communication dated 27 November 2001 and earlier directions issued by this court in writ petition number 58817 of 2016 and other relevant law which is applicable for consideration of granting aid in accordance with law.
From on the word granting aid from 1/1/13 ಅಂತ as per earlier.
As consider in accordance with law.
ಅಂದ್ರೆ ಏನೋ ಸ್ವಲ್ಪ ಬಿಟ್ರೆ ಅವ್ರು ಮತ್ತೆ ಒಂದ್ ಸ್ವಲ್ಪ ಮತ್ತೊಂದು
ಏನು ಮಾಡಲ್ಲ, ಮಾಡಿದ್ರೆ ನಾವು ಇದ್ದೀವಿ ಕೂತ್ಕೊಂಡು ತೀರ್ಮಾನ ಮಾಡ್ತೀವಿ.
ಆಯ್ತು ಸ್ವಾಮಿ, ರಿಟೈರ್ಡ್ ವರ್ಷ ಏಜ್ ಆಗೋಗಿದೆ.
In accordance with law. See, they have applied that wrong provision and this thing. ಯಾರೋ ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ರೆಡಿ ಮಾಡ್ತಾರೆ, ಯಾರೋ ಸೈನ್
ಕೊಡ್ತಾರೆ ಅವ್ರು.
Yes.
ಅಲ್ಲ ಟೈಮ್ ಫಾರ್ ಟೈಮ್ ಫಾರ್
3 months from date of receipt of copy of this.
Application.
All pending applications. Fast over will come back, Mr. We are on that. Yes, so many matters fast over. Yes.
Shivani Shetty for petitioner, Jayakara Shetty H.
Serial number?
55, sir.
Your Lords, Your Lords, I'm ready to argue the matter.
No, that she don't want your objection. She's. Yes. Yes, at the request of counsel for.
Your Lords, if it may be had on,
Read this matter on 18th.
Your Lords, next week, if it may be
Next
had.
week only 18th.
Obliged, Your Lords.
18th.
Serial number 56, Tilak Raj SP for petitioner, Mahesh Chaudhary.
Yes.
Pass on, senior is engaging in quota number 1.
May be taken next week.
Immediately.
Yes. Next week. Yes. Read this matter on 24th. Yes.
Serial number 57, Vijay Raghava Sarathi for petitioner.
Appearing for the petition.
Palmanalli.
Yes.
The short point is this, Your Lordship.
Yes.
The petitioner who is working as a assistant professor, who is under the UGC pay scale in a granting aid college,
Yes.
degree college,
Yes.
from 1992 to till 2008. Later on, while working in the said post, which is approved by the state government, it is included to the salary grant, and UGC pay scale is also extended.
Yes.
One of the post is notified in the PS Engineering College, which is also a granting aid institution. Having obtained NOC from the college in which I am working, I have participated in the selection process. I have been selected. In pursuance to selection, the government itself has approved my selection.
Yes.
Followed by the approval by the government, the college, the management who is supposed to be the appointing authority,
Yes.
they have issued an appointment order calling upon me to join for the duty. And my appointment is also forwarded to the department as well as the KCSR is applicable only for the government. KCSR is applicable only for the government servants. It is not applicable for the granting aid institute. This issue is settled by the Sambal Court because when the terms and conditions of the appointment, either for the private colleges or for the government colleges, is one and the same. And the pension is determined under the KCSR even for the private aided institution. They cannot deny the fruits of the. This is the only question. The endorsement is annexure A. Page 24.
Yes.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ PS ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜು ಮಂಡ್ಯ ಸಂಸ್ಥೆ ನಿವೃತ್ತ ಪ್ರಾಧ್ಯಾಪಕರಾದ ಶ್ರೀ ಶಿವಲಿಂಗೇಗೌಡ ಇವರು ಉಲ್ಲೇಖದ ಮನವಿಯಲ್ಲಿ ತಾವು PS ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜಿನಲ್ಲಿ ನೇಮಕಾತಿ ಹೊಂದುವ ಪೂರ್ವದಲ್ಲಿ ಕಾಲೇಜು ಶಿಕ್ಷಣ ಇಲಾಖೆ ಅಡಿ ಭಾರತೀಯ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಅನುದಾನಿತ KM ದೊಡ್ಡಿ ಇಲ್ಲಿ ದಿನಾಂಕ 29/1/1992ರಿಂದ 29/2/2008 ಅನುದಾನಿತ ಉಪನ್ಯಾಸಕರಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿ ನಂತರ PS ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜ್ ಭೌತಶಾಸ್ತ್ರ ವಿಭಾಗದ ಸಂಯೋಜಿತ ಪ್ರಾಧ್ಯಾಪಕರ ಹುದ್ದೆಗೆ ನೇರ ನೇಮಕಾತಿ ಮೂಲಕ ಆಯ್ಕೆಯಾಗಿ KCSR ನಿಯಮ 252B ರನ್ವಯ ಭಾರತೀಯ ಕಾಲೇಜಿನ ಕರ್ತವ್ಯದಿಂದ ಬಿಡುಗಡೆಗೊಂಡು 1/3/2008 PS ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜ್ ಕಾರ್ಯವರದಿ ಮಾಡಿಕೊಂಡಿರುವುದರಿಂದ ದಿನಾಂಕ 29/1/1992ರಿಂದ ತಮ್ಮ ಸೇವೆಯನ್ನು ಪರಿಗಣಿಸಲು ಕೋರಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ಪರಿಶೀಲಿಸಲಾಗಿ ಖಾಸಗಿ ಅನುದಾನಿತ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗಳ ನೌಕರರು ಈ ಹಿಂದೆ ಬೇರೆ ನಿಯಮ 41A ರ ಅವಕಾಶಗಳು ನೇರವಾಗಿ ಅನ್ವಯಿಸವಾಗತಕ್ಕದ್ದಲ್ಲ. ಅನುದಾನಿತ ಸಿಬ್ಬಂದಿ ಪ್ರಕರಣದಲ್ಲಿ KCSR ನಿಯಮ 42B ಈ ಅವಕಾಶಗಳು ವಿಸ್ತರಣೆಯಾಗಿರುವುದು ಕಂಡುಬರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಈ ನೌಕರರು ಸಂಬಂಧಿಸಿದ ಪರಿಗಣಿಸಿ ರೂಪಿಸುವ ಯಾವುದೇ ಪಾಲಿಸಿ ನಿರ್ಧಾರ ನಿಯಮ ವ್ಯಾಪ್ತಿ ಪರಿಶೀಲಿಸತಕ್ಕದ್ದು. ಮೇಲ್ಕಂಡ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಬೇರೆ ಅನುದಾನಿತ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಯಲ್ಲಿ ಸಲ್ಲಿಸಿದ ಅನುದಾನಿತ ಸೇವೆಯನ್ನು ವೇತನ ಸಂರಕ್ಷಣೆ ಮತ್ತು ನಿವೃತ್ತಿ ವೇತನ ಸೌಲಭ್ಯ ಪರಿಗಣಿಸುವುದಕ್ಕೆ ನಿಯಮಗಳಲ್ಲಿ ಸ್ಪಷ್ಟವಾಗಿ ಅವಕಾಶ ಕಲ್ಪಿಸಲಾದ ಕಾರಣ ಡಾಕ್ಟರ್ ಶಿವಲಿಂಗೇಗೌಡ ಇವರು PS ಇಂಜಿನಿಯರಿಂಗ್ ಕಾಲೇಜ್ ಮಂಡ್ಯ ಸಂಸ್ಥೆಯಲ್ಲಿ ಅನುದಾನಿತ ಸೇವೆ ಸಲ್ಲಿಸುವ ಪೂರ್ವದಲ್ಲಿ ಕಾಲೇಜು ಶಿಕ್ಷಣ ಇಲಾಖೆಯ ಭಾರತೀಯ ಪದವಿ ಕಾಲೇಜು ಅನುದಾನಿತ KM ದೊಡ್ಡಿ ಸಂಸ್ಥೆಯಲ್ಲಿ ಭೌತಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರಾಗಿ ಸಲ್ಲಿಸಿದ ಅನುದಾನಿತ ಸೇವೆಯನ್ನು ವೇತನ ಮತ್ತು ಸೇವಾ ಸಂರಕ್ಷಣೆ ಪರಿಗಣಿಸಲು ಅವಕಾಶವಿರುವುದಿಲ್ಲ ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ. This very matter was subject before this honorable court interpreting section 87 of the Education Act. Your Lordship kindly take, I just sent for Xerox of judgment. '87, Your Lordship. Take page 18.
Page 18.
This is page 18, para 15. A judgment ಕೊಡ್ತೀನಿ ಅದನ್ನ extract ಮಾಡಿದ್ದೀನಿ.
Yes.
This honorable court on Ketina of decision has held that as per section 87 of the Karnataka
No, I
education.
don't think any ambiguity in that provision.
There is no ambiguity. The only issue is that
Yes.
they extended me salary grant. They extended me the service which I am rendered in the previous institution for the purpose of promotion to the professor, and my salary is protected till my retirement.
Yes.
How can they deny me?
Mr.
And it is extended to my own colleague who has been also joined from Malnad Engineering College to the PS Engineering College.
Yes. Yes, Mr.
Lord, may I request, Lord, the endorsement is issued only considering that he got a new appointment, Lord.
Yes.
That is one, but the contention in the endorsement that he is saying that the benefit which are there in the
No, your endorsement says that KCSR
That
is
is
not
not
applicable to the private education institution. Section 87 says that same as related to the government employees,
That is
if otherwise prescribed under the rules.
Lord,
Is there any other rules prescribed for that?
to that extent,
Private education institution.
I want to read again that 287B because it's only for the qualification, my Lord. That is
No, no, no,
the
no.
chapter
Conditions
itself,
of service, age,
Yes.
the
recruitment, and
chapter
retirement.
itself speaks about the qualification, my Lord.
No, you read that.
Lord, terms and
Qualification,
conditions of
condition
service
of
of
the
the
service of
employee in
employee.
private aided institutions.
Minimum qualification for
minimum
requirement, age, recruitment, retirement for the employee in the education institution receiving finance grant from the college shall be same as those applicable to the corresponding category of that only qualification. Age of recruitment and retirement for the employee in the education. What is that, this thing judgment as discussed? If you read that.
For the pensionary benefits itself, it has been interpreted. Your Lordship kindly take page 18. I will just get the judgment.
Because.
Yes,
they
that
are
has been interpreted. That is the only point which has been interpreted by
Yes.
the High Court.
Yes,
Para 15, I may be permitted to read, Your Lordship. I will get the judgment also.
yes.
This honorable court on Ketina of decision has held that as per section 87 of the Karnataka Education Act 1983,
Yes.
the government cannot prescribe different service conditions to employees of private education institution, as held by the Honorable High Court in the case of Sri Shankar MR versus State of Karnataka, reported so and so. Prescription of different service conditions to similarly placed employees is arbitrary and discriminatory and violative of Article 14 of the Constitution. Nobody can dispute that KCSR provides for pensionary benefits to the employees of private aided education institution private aided education institution. If the same benefit is not provided under the rules, the same will not be inconsistent with the KCSR. As per Rule 6 of the rules, if it follows that the provisions of KCSR will prevail, consequently, the petition is entitled to the pensionary benefits. Hence, the contention of the learned government pleader that the third respondent is governed by a separate set of rules and the government orders. And the rules applicable to the private education institutions are not applicable to it, cannot be accepted, and say hereby rejected.
No, we'll see that judgment.
I will get it.
What is that actually?
And apart from that, even for the collegiate education, they have separate rules for recruitment. Even under that rules also, it has been incorporated.
No, if it is incorporated, it is different. If it is not incorporated,
Only to the extent that what is the service conditions prevails in the government institution is mutandis applicable to the private aided. Your Lordship,
Anta judgmental helidare, but section doesn't say like that.
Your Lordship, kindly appreciate conditions of service. The word used is conditions of service.
No, you see that the state government may, after previous publication, make rule regarding to that recruitment conditions of the service, including the right employees in recognized private education institution. Rules ಮಾಡಬಹುದು ಅಂತ 87
ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ
ಕೆಳಗಡೆ provided that minimum qualification for requirement of age recruitment ಇದೆಯಲ್ಲ ಅದಕ್ಕೆ ಏಜ್ ರಿಟೈರ್ಮೆಂಟ್ ಗೆ ರೂಲ್ಸ್ ಮಾಡದೇ ಇಲ್ದಿದ್ರು ಕೂಡ ಗವರ್ಮೆಂಟ್ ದೇ ಅಪ್ಲೈ ಆಗುತ್ತೆ. ಇನ್ ಬಾಕಿದಕ್ಕೆ 87 ಅಲ್ಲಿ they have a power to make a rule ಅಂತ. That is what that understanding. I don't know how that judgment has been.
The judgment has rendered taking into the aspect of conditions of service.
No, see, you read that. Otherwise, they need not say provided that minimum qualification for recruitment age or recruitment of the retirement at but particular ಹೇಳಕ್ ಬರ್ತಿರ್ಲಿಲ್ಲ ಅವಾಗ.
I will go further for the purpose of
see, benefit for the retirement has been omitted on 1995.
Number 1.
It is omitted there. That means to say that they don't want to include that.
It is included, and that has been if otherwise, if your Lordship, pensionary benefits has to be accrued on for a private education, so even under the KCSR only, there is no separate provisions for the pensionary benefits.
No, if there is no separate provision, if where is that law which says that it is applicable?
Conditions of service includes everything.
No. What they said, the state government may, after previous publication, make rules regulating the recruitment and condition of the service, including the rights as regarding the disciplinary matter for the employees in recognized private education institution. 87 ಅಲ್ಲಿ they can make any rules. That is the power which has been given. ಅದು proviso ಏನು ಹೇಳಿದ್ರು ಅಂತಂದ್ರೆ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಏಜ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ರೂಲ್ಸ್ ಇಸ್ ಕನ್ಸರ್ನ್ ಅಕಸ್ಮಾತ್ ಅವ್ರು ಏನು ರೂಲ್ಸ್ ಮಾಡದೇ ಇಲ್ದಿದ್ರು ಕೂಡ ಸರ್ವಿಸ್ ರೂಲ್ಸ್ ಇಸ್ ಅಪ್ಲಿಕೇಬಲ್ ಅಂತ.
The issue was here. Para 2, Your Lordship.
Yes.
Para 2, Your Lordship.
Yes.
The rejection of claim was on the ground that the third respondent is governed by a separate grant in aid code, and the government orders applicable to the other aided private education to the general rules expenditure disbursement of grant in aid laid down in the Karnataka Finance Code and other financial manuals, where the rules laid down in the code appears to be inconsistent with the provisions of Karnataka Financial Code and Karnataka Civil Service rules. The rules contained in the latter shall prevail. From the above, it is clear that the rules are supplementary to the general rules of expenditure and disbursement of grant in aid under the Karnataka Financial Code and other financial manuals. Therefore, what is prescribed under the separate rules to the respondent number 3 alone shall not be taken into consideration for determining the release as sought by the petitioner in the writ petition. The prescriptions made under the rules.
Para 8, my lord. Para 8.
Para 8 is the word which the court has come.
Yes.
There is no justifiable reasons for denying the benefit of pension to the petitioner. Having regard to section 87 of the Karnataka Education Act 1983, the government cannot prescribe different service conditions. Kindly mark this. This is what different service conditions to the employees of the private education institution. Prescription of different service conditions to similarly placed employees is arbitrary and discriminatory and violative of Article 14 of the Constitution. Nobody can dispute that the KCSR provides for pensionary benefits to the employees of private aided education institutions. Aided education institution. If the same benefit is not provided under the rules, the same will be inconsistent with the KCSR. And Rule 6 of the rules, it follows that, the provisions of KCSR will prevail. Consequently, the petitioner is entitled to pensionary benefits. Hence, the contention of learned government pleader that the respondent is governed by the separate set of rules and the government order and the rules applicable. Granting aid, you lordship, get it in chapter 4. Rule 20. Rule 25, Lucas. Rule 25.
Yes.
Qualification and conditions service of employees. The minimum qualification of recruitment, age of recruitment and retirement of employees in private education institution receiving aid from the state shall be the same as those applicable for corresponding category of employees in the government education institution. So,
No, this is for whom?
this is for the collegiate, in which
You are the collegiate.
earlier I was working in the collegiate education. Later on, I shifted to technical. From 1992 to 2008, I was an assistant professor in the Bharati Degree College, which is a granting aid issued under my appointments governed by these rules.
Yes.
From 2008, I have once again been selected after getting approval from the government to a PS engineering college under ACT pay scale. Both I have received the UGC pay scale only, and my service which I am rendered past is carry forward for the purpose of salary grant as well as for the purpose of service rendered.
Yes.
Now, only after my retirement, they say that I'm not my service cannot be counted. That cannot be done so. And your lordship has asked me, KCSR is not applicable. While relieving me, the very same government has relieved me, approving my resignation under 252B. Having said so, that too retrospectively.
Yes, Mr. What is your stand now?
Lord, may I make
I'm
one
the
submission?
only person I have segregated. There are 6 other persons who have been given this extension, and they have been given
252B, my lord. That is not, I am not disputing, because the pensionary benefit, my lord, it is already prescribed under the Karnataka Private Education Aided Institution Employees Pay and Pension and Other Benefits Order.
Have a rule. Rule is there.
Also,
Where is that?
that act is there, my lord, but rule I had to.
No, act is there. It's enough. If prescribed rule is necessary or not. If act is clear.
That is Karnataka Private Aided Institutions Employee Regulation of Pay, Pension and Other Benefits Act.
ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಬುಕ್ ಅಲ್ಲಿ ಇದೆಯಾ ಅದು ಇದರಲ್ಲಿ ಇರಲ್ಲ ಎಜುಕೇಶನ್
ಈಗ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಚೆಕ್ ಮಾಡ್ಬಿಟ್ಟೆ ನಾನು.
But in that judgment, where that code is inconsistent to that KCSR,
will prevail.
Without challenging the code, court has decided that.
Lord, that
judgment, they should have been challenged that code.
That is the Act of 2014, my lord.
Which one?
This Act, my lord, what I am reading.
2014.
This judgment is rendered in 2003.
That has been struck down.
Act 2 of 2014.
Struck
2
down.
of 2014 is pending before the division.
Sorry, my lord.
That is one.
That has been struck down by the court. That has been.
What is that says that? That is only for this thing, Mr. Pay and pension.
Pay and
for
pension.
Non-aided period.
Non-aided period again.
Non-aided period, whether this court and Supreme Court have
Act
said
2.
that their entity is not in respect of this. Now, is there any granting aid under the granting aid code which applicable for that pension? Because that judgment, it is said, it is for in a different institution. Then what is the stand of the government, Mr.? Whether KCSR is applicable or not, because it's
in their endorsement, they said KCSR is not applicable.
What is your objection? Have you filed it?
Objection file madila.
Then you have to take a stand, Mr.
The interpretation of the court is service conditions includes everything.
Yes, no, they see. If the judgment of this court is considered, they need not make any rules because it should be similar to that.
Similar to the,
They can't do any.
they cannot be a two different service conditions for the private and
To pay allowances, including travel allowances, course of time, which was in allowance, earned leave, rules.
the government cannot prescribe different service conditions to the employees of private education institutions.
Yes.
That is what.
No, ultimately, cannot be discrimination for that, this thing. Now that whether you have any rule